The health and social care sector in the UK benefits from the contributions of skilled overseas workers. To sponsor these vital members of the workforce, providers rely on sponsor licenses issued by the Home Office. But what happens when those licenses are suspended or revoked? These consequences can be quite severe, impacting patient care, service delivery, migrant workers, and ultimately the growth of the service provider itself. Joining us on this episode are two phenomenal guests. Dudley Sawyerr, a health and social care consultant and business strategist with People Care Services, who spends years supporting providers within 18 London boroughs as the chair of the Registered Managers Groups LCaS. Our second guest for today is Andrew Nyamayaro, Principal Solicitor at Tann Law Solicitors Limited and former President of the Warwickshire Law Society. And together, we will be discussing the impact of suspensions and revocation of sponsorship licenses, in addition to strategies for maintaining compliance and the value of legal expertise in navigating these complex situations. It's a pleasure to have you both on our podcast today. You're very welcome.
Thank you very much. And I'm very welcome to come here as well and being invited once again on a subject which not only is a hot topic for those in health and social care, but seems also as well to be a hot topic in the political realms as well. So it's really hot. Migration, retention, helping a sector. What more could you ask for? So thank you for inviting me in.
Thank you so much.
So we want to give listeners actionable insights, like I said earlier, to avoid pitfalls. In your experience, what are the top 3 most common mistakes that lead to sponsor licenses either being suspended or revocated?
Okay, so in my experience, and I've been doing a lot of audits for businesses, the 3 main reasons why sponsor licenses are revoked is A, failure to maintain the sponsor license management system, the SMS. The people or the owners of the businesses, they do not log in to do necessary updates, and they do not necessarily report migrant worker activities in time. So those misfortunes or those things that they do not report may be grounds for mandatory revocation. And unfortunately, most people suffer as a result of that. Secondly, it's something that people think is not important, but people don't do a clean sweep of their social profiles of the businesses online. So the Home Office is doing a lot of remote audits online. So if you've got information that is slightly misleading, even in the littlest sense, the Home Office can suspend your sponsor license for that. For example, if you have got an address on whichever, maybe Google My Business or Bing, that is different from what is on your website, that can cause issues for you to be suspended, or any other things that you mentioned on your website that might be in breach of the requirements of a sponsor, but you do not do necessarily. They look at everything like the company's house, the HMRC, and so forth. So it's good to have a clean sweep. If you're, for example, you are doing recruitment activities and then you don't do them anymore, make sure that you update your company's house profile and you update your social media and your profile online. The last thing that people don't necessarily do, which is important, is maintaining proper systems, procedures, and policies. Some people don't have policies, or if they have them, they're all over the place. And some people don't have systems. There's a lot of web-based systems, online systems that are available. As much as people are still free to use their own manual systems that they would want to use, but it's important to have systems that help you manage your sponsor license.
Thank you for that insights. Out of all that you've listed, as a consultant myself, one of the things that, from my experience working from providers, is they don't really see a lot of value in having either an online digital presence that correlates with their physical provision. So I totally agree with that. And it's something that could be easily missed, because that's an area, digitizing social care, and not just your systems and processes, but your online presence as well, is something that a lot of providers don't do, from my own personal experience. So knowing just from what you've said that this is an area, this is a pitfall, it's definitely something that I'm sure a lot of providers would have to would look into to improve their services.
Thank you so much. Yes.
So, Andrew, does your firm specialize in immigration laws and labor laws specific to health and social care?
Well, so we do immigration, all sorts of immigration, anything immigration we do. Labor or employment law we do as well. We represent employers and employees alike in employment matters. We have got experience in dealing with both business and personal immigration. And for the health and social care, we help the businesses in that regard. Not only that, we also do regulatory law. So if, for example, your business is facing deregistration or cancelling of your authorization from the CQC, Ofsted, different regulators that you deal with. We have got experience in dealing with those matters in the Social and Health Care Tribunal, the Employment Tribunal, Immigration Tribunal, all the way to the High Court. So yes, we do specialize in health and social care, even for people that are regulated by Social Work England or the NMC or the businesses. We do all that kind of work.
Well, that's fantastic. That's good to know, because it's quite difficult. A lot of requests that I've gotten from our clients is solicitors that are actually specialists in health and social care, because there are solicitors that they specialize in labor laws, but not particularly health and social care, because that's quite a niche. To be specialized in that area is quite niche. So I wanted to clarify that, so our listeners know that they can come to you for issues surrounding anything to do with health and social care. So be it regulatory issues with CQC or Ofsted or other regulators, and now the Home Office. Can you share a success story where you've helped a company overturn a suspension or revocation?
Okay, so in terms of overturning a revocation, about not so many weeks ago, we had a client that had been suspended, and then after the suspension, we did representations to the Home Office. After we did the representations, we continued to nudge the Home Office to make a decision. And as you would realize and know, at the moment, the Home Office, they are taking their time to respond to representations that have been made by the company or their representatives. They then came up with a revocation, citing reasons that the company over recruited employees. They did not really recruited employees that met the criteria for that particular visa at the time. When we were challenging the Home Office, it was still the old 6145 and 6146. That is now the current 6135 and the 6136 in terms of the SOC codes.
Okay.
So we challenged the Home Office because they clearly did not understand from our perspective how to deal with businesses that are in the space of domiciliary care, how the Home Office was calculating the hours of the employees, because they were saying you are not giving your employees sufficient hours, then therefore you do not have genuine vacancies in your business. And they were also citing a generic reason, which they are citing these days, that the local authorities or the buyers do not specifically mention the hours that they allocate you. You know, the local councils or the counties then don't normally cite specific hours because it's a framework agreement.
Yes.
Your hours can then be seen from different work that you do. If you then produce like your rotas, and you produce all the kind of information from your HR systems. So we challenged them. We calculated the hours, how it's supposed to be calculated. We gave them the information about the requirements, particularly the English requirement, and the Home Office reinstated that sponsor license.
Thank you for sharing that, Andrew. Having had a lot of inquiries from providers who are either concerned about their licenses being suspended because they've either had a fellow service provider's license suspended, and there's either, I wanted to address this, and I wanted people to know that there are firms like yourselves out there that they could trust and they could come to. And sometimes, and especially when dealing with the Home Office, it's not a situation that you could deal with by yourself. It's very complex, and having support from companies like yourself, it's going to be key when dealing with suspension and revocation. Typically, there's a 20 working day response window. Can you break down how you would strategically use that time with a client to maximize their chances of lifting the suspension, if any? Because sometimes, well, not sometimes, there's a client that had they received the letter and they were quite concerned about 20 days. They didn't think it was a lot of time, especially for smaller businesses who typically they don't have their ducks in a row. They have their paperwork everywhere. So what are the strategies that your firm would use?
Okay, so what normally happens is that when a company receives the revocation letter, or in this case, it's the suspension letter, the Home Office will give them a 20-day period in which to make their representations. And sometimes, depending on how busy the level 1 user is, they might not even notice it after even for a few days, or it might, in other cases, go to the junk mail. So my point being that it is important for the level 1 users to be regularly checking their emails, and also to be taking a look at their junk mails, because it might go into the junk mail and you might not be able to see it. And I think it's always a bit embarrassing when you hear it from your employees, because the employees are always checking about these things. There are some websites that do updates every day for suspended and revoked companies. So employees are always checking, or if employees have got their dependence applications going on, they've been put on hold, things like that.
Yeah.
But for the 20 days, if the company is already our client, we would be working with them already. So we kind of know where they are at in terms of their systems, processes, and procedures. And from that point, if we had not done a compliance audit on them, we arrange to go and do a compliance audit. We go and talk to the employees that were interviewed. If they are available, we cannot force them. We review the Home Office notes, the files that the Home Office looked at in the systems of the company. And after that, we then do our representations and send to the Home Office. So whereas the company is not already our client, our strategy is that A, we go and do a compliance audit ourselves, and then B, we then do the representations to the Home Office. Where they are already our client, we can go straight to do the representations, but it's not an easy process. It's a tedious process to do this, because in the suspension letter, the Home Office would have asked for a number of documents. So the first thing that we need to do is to sit down with the level 1 and record a statement, a detailed statement explaining all the maybe problems in the company, pitfalls, etc., and anything that has been identified by the Home Office. We then help them to gather the evidence. So normally they would have asked it, say, for a company tree, the organizational structure of the company. They would ask for the rotas, they would ask for the contracts, they would ask how your employees satisfy the requirements of the SOC codes in which they are employed. They will ask for your policies, if you've got any HR systems and so forth. So we We have to go through each and every document one by one to try to help the employees. We review all the contracts, we review your systems. If you use an HR system or a service user system, there's quite different ones. Some systems can cater for both HR and service user management. Some are just specializing in service user only, and then others specialize in HR only. We look at that, we review all those documents, we then do the representations where we address the points that have been raised by the Home Office, applying their own guidances and also case law.
Wow, that's really a thorough service that you provide. So you mentioned that you have there are two separate services if it's an existing client or if it's a new client. So I know that a lot of providers shy away from retainership. So if someone was thinking about, if a provider out there wanted to take preventative measures and they were thinking of being your clients, how would they go about that?
Okay, so we have got what we call the SME package, because according to the Home Office, any company which has got a turnover of less than 10 million is an SME. So most of our clients are SME. So we've got an SME package, which has got 4 packages. We have got the bronze, silver, gold, and platinum. So for most people that want to go on a retainer, they might, if it's just for the Home Office, they'll normally pick on the bronze package.
Okay.
And then we can then support them monthly with their SME sponsor license. If people don't want to be on a retainer, we have got an hourly rate. So if they want to come to us on an ad hoc basis, maybe they've applied for COS and they've faced problems, or maybe there's an employee that is causing problems for them and they want employment law advice, they can just book an hour or 2, depending on what is the issue. And on average, our hourly rate is £200. But it then works out more expensive if you are going to have more issues to be dealt with by lawyers, because our bronze package for the sponsor license is £200 per month to give you almost 2 or so hours of support over the period of the month. So we've got these 2 packages, the hourly rate or the retainer rate. And so we just help the companies to stay compliant. We have got information that we regularly send to them. We are normally logging into the systems, different systems all the time. So all the announcements and the messages that done by the Home Office, we know it every day. You know, some level 1 users, they rarely log in. I had one client who was not even aware that they were supposed to update the SME about the company details until when they were applying sponsor certificate of sponsorships of their employees. We had about a week left for their visas to expire, and the Home Office it asked them further information for something that was on the notice board. So you know it was difficult for them because the visas were about to expire as well. So we take our time to look at all those things when we are on a retainer.
That's brilliant. I love that you offer a flexible package. And I know that one of the reasons I like your services is because I work with a lot of small businesses as well. And if there's one thing that is common between small businesses is use of funds. So you being able to provide an affordable service with a lot of value is one of the things that I truly love about the services that you provide. Because usually when people think of solicitors, they think lots of money. But legal counsel is something that I always encourage all of our clients to go with or to take whenever possible. So knowing that you have a package of £200 did you say it was £200 per month for the bronze package, and it gives you 2 hours monthly consultation?
Yes.
I think that's absolutely brilliant. So lots of people will be happy to hear that. So for small businesses who might be overwhelmed, what's the bare minimum they should be doing to stay compliant and avoid getting in trouble?
I'm going to disappoint the listeners with my answer, unfortunately. When it comes to the home office sponsor license, there's no bare minimum. It's the maximum that you have to do.
Okay.
You know, when you get a sponsor license and you are the level 1 user, or you are an authorized officer, or anyone involved with the sponsor license, I would say log into that system as many times as you can, and I would say at least 3 times a week. And anything that happens that you are not sure of, you have to check the guidances all the time. There is 12 manuals that are online from the Home Office as guidances. And the Home Office expects you to know about those 12 manuals, how to do it. And because they do an idiot guide in terms of running the SMS, which is demonstrated in those 12 manuals. So you have to be on top of things, because for the slightest mistake, the Home Office will suspend or even revoke your sponsor license. If you just miss reporting something which is supposed to be reported within 10 working days, or updating something that is supposed to be updated within 20 working days, and the Home Office picks on it, then they will likely revoke or suspend your license. So you need to be on top of things. And if you cannot be on top of things, then you need to consider outsourcing that requirement to third parties like solicitors, consultants, or other people that can help you. And if you're a busy person, then you need to have 1 or 2 or more level 1 users that can, instead of just having 1 level user, can have more than 1 level user, 1 level 1 user, so that you share the responsibilities. So with the Home Office being a level 1 user, effectively you are an unpaid Home Office caseworker.
Okay. Well, thanks for the clarification. You heard it from Andrew, there is no bare minimum, unfortunately. It's the maximum. You have to go all the way, because a slight issue or non-reporting of anything could lead to revocation or suspension, which no business wants to do, or wants to have rather. Dudley, do you have anything to add to that?
No, I mean, I agree. I think the problem starts from the beginning, because they've expected a lot of individuals who didn't have knowledge to all of a sudden be experts. And due to 1 or 2 reasons, some are trying to save money, and others as well think they can do it themselves. I think this is the problem. And it's not the issue over, my problem is now, what is this, the Home Office and UKVI are going back to those people they issued all the certificates, and now penalizing them for not getting it right, but they offered it to them in the first place. So it's partly not fair, but it also then means now that they should make sure, if it's not a mock audit or an audit themselves, really look over definitely what they've done, and then make sure they keep their records up to date for anyone who's presently there or anyone who's coming in there. And this is a way of keeping compliant. Keep a file, a record, have someone who's purposely in your business looking out for it. If not, outsource it to someone.
That's exactly what Andrew said. Because there are lots of, you're a consultant yourself,
Yes.
and just so are we. We deal with lots of small businesses, and some of them have already had visits from Home Office, but majority haven't, and they are certainly very concerned about that visit. So what Andrew said earlier, ensuring that you understand the 12 manuals, which if companies or small businesses are not doing that already, if you're a small business who isn't doing that, please ensure that you start that process. Or as Andrew said, you can outsource it, because it's a lot to read and understand, and some of the words could be quite complex. So if you do need support, there is support out there. And as you heard previously, you can always engage Tann Law Solicitors. You can engage their bronze services, so they can actually help you through this process, understanding the 12 manuals, and also ensuring that you check your system 3 to 4 times a day to ensure that there's nothing that you've missed out. So yeah, one of the things we aim to do at the Health and Social Care Business Podcast is to empower our listeners to be proactive. Now, that being said, are there any red flags companies should watch out for that might indicate that they are at risk of a compliance visit or actions from the Home Office? I know you previously said the level 1 user needs to constantly check, but by doing that, you would see any red flags or anything that needs to be done. But in addition to that, what other red flags, especially to do with like the daily activities that the company does?
Okay, so for the companies, the red flags that are normally there is, in fact, every company at some point should expect a visit from the Home Office. And at the moment, as we speak now, the Home Office is doing more of unannounced visits rather than announced visits. They'll just come in at any time and just say to everyone, stop what you are doing. We are taking over. Give us this ABC. Call us this employee to come and interview them and so forth. And they normally tag along officers from the human trafficking and modern day slavery department, etc. So the red flags are that you should always have your systems in place. If your systems are not in place, that's going to be more likely to call into the Home Office. You should be paying your employees, because if you're not paying your employees, that information, the RTI information, is going to feed into the HMRCE, and the HMRCE works alongside the Home Office. And you should be able to treat your employees right. And if you are not treating your employees right, they are likely to be the whistleblowers that we will whistleblow to you, to the Home Office. Even the service users as well, they might be whistleblowers. So again, you should be able to make sure that your employees have got the relevant training, they've got the relevant experience, and they've got the relevant, at least minimum standard of spoken English, so to say, because I've had some clients having problems because their employees can't speak English, for example, and when they go to the service users, that is causing them problem. And why that has been happening is that most people were recruited online, and when they were recruited online, if you ask me a question, it might be someone behind a curtain or whatever giving the answers, and the person that then comes to your company is a different person. And there's a recent case that came from the tribunals, in which it has been identified that there's been a lot of cheating in the English test. So someone might write the English test, and the person who eventually comes is a different person who speaks not even an iota of English. So the red flags are always there, but effectively, if you have got your systems in order, you've got your processes in order, and you've got your procedures in order, things should be fine.
No, thank you very much. I think, yeah, you've really touched on a lot of the areas. I think the biggest red flag is that now various parties are speaking to one another, which is one of the biggest things that people are not aware of. HMRC, we now are really involved. CQC as well, and that's another area as well, because CQC will also come in, and if, for example, something is brought up, CQC will then report it as well. So also as well, from a normal inspection, CQC are looking at that. As you mentioned as well, the other, your employees as well, if they're not having enough hours, if they're not being treated fairly. So you have to make sure all these things are done properly. But also as well, it's your duty as well to you let the UKVI and you update any changes in circumstances of your workforce. It's important that you do this. The Home Office are looking at things at any time of what may happen if you don't, especially when it comes down to when they come to their checks. So I think one of the most important things is just, as has been said before, making sure your hours relate to the amount of hours they're meant to work, also as well the salary as well, and if anything, you must also notify the Home Office via your SMS system if a worker's salary is reduced for any reason not related or permitted, regards to absence after you've assigned a COS. And also, if there's a deduction in salary and hours, the workers can continue, but you have to let them know. So the key thing is to be open and transparent. They do not want to take your license away, but they will do if you're not compliant. And I think the biggest red flag for me, which people are not aware of, is unlike a normal inspection, at least in the inspection, you may be able to speak to them. This system isn't like that. So it's either straight, there is no in between, and which is the unfortunate thing. And this is even worse to understand.
Yes. When Andrew spoke about the unannounced visits, because CQC does unannounced visits as well. But would you say, in comparison to the Home Office, CQC is a bit more lenient? Because sometimes if you don't have certain things, you do get some time to get your policies in place, to get your all of the things that you've been, all your non-conformance, you have time to address it. But with the Home Office and what you said earlier, ensuring that you're always ready, the consequences are more dire with the Home Office. Would you say the Home Office visits are more stricter than the CQC?
So I'm going to come in here very quickly. So I think the result of any result, a bad result is always bad, but you're working with almost a system when you're talking of the Home Office. With the CQC, for example, you may get a good inspector, but then you could get a very bad inspector and may make your life twice as bad. So that may depend on the day. Whereas with this system, it's straight down the middle. There is just one set of rules and it applies across the board. The difference is after the fact, you may be able to address them, but with CQC, it's very difficult to change that. On the day, you may have some influence depending on the inspector or not. So that's what I would say is probably the open stark difference, in my opinion, anyway.
Yes, I think I agree with what Dudley have said. I will not add much more. I mean, he's even emphasizing it with his hands to say it's a straight line. So that's what exactly it is. Yeah.
Yeah. I mean, I've heard stories. Many would tell you stories from CQC inspectors doing this, doing that. But then I've seen people have been very sad with inspections where they've come in and people almost say heavy-handed and they're from the Home Office visit and it's a shock to the system. So yes, it's not easy.
Yeah, so the key takeaway is always be prepared, especially because the health and social care is a regulated sector. You're either being regulated by CQC, Ofsted, Home Office. Audit compliance is something that a lot of providers, from my experience, they should emphasize more on, and they should really take it a lot more seriously, because it's not being found non-compliant could lead to loss of businesses, which nobody wants. So a lot of, just like I've said, a bit like compliance, a lot of providers, from my experience, they underestimate the value of legal counsel. You, Andrew, more than anybody, understands the importance of legal representation during a home visit, because you go into court, you represent your litigation lawyer. So can you explain how a solicitor can actually support during this stressful period?
Okay, so where someone is being visited by the Home Office and they are either still under suspension, revocation, or maybe we are now doing the judicial review in the court, it is important to have legal counsel as much as possible. I do understand that some of the businesses, due to their size or a turnover, they might not be able to afford legal representation, but it's important. One thing that I also want to say to the viewers is that there are some insurances that you can get that might cover you on some issues relating to your legal matters. So when you get a visit from the Home Office, check with your insurances. If you've got a business insurance that has got legal cover, check with them if it covers representations for the Home Office, etc. And some people also have got different aspects of cover from consultants. Dudley, I think he does some consultants for businesses, which also touch on legal matters. And then there's other companies, which I will not mention by names because they're not part of this podcast at the moment. So we have got some companies that offer HR support. Yourself, you do offer those kind of things.
Yes, we
HR
do.
support, compliance.
Yes.
It's not, it's everything that is connected, whether it's CQC compliance, Ofsted compliance, Home Office compliance, all those things. There's law everywhere when you're in the health and social care space. So it's important to have a lawyer, particularly, or rather counsel or advice. During the representations, I've seen some representations that have been done by people because they are very emotional at the time, not only stressed, but emotional, because you are doing your best and you are taking care of your service users and you've got the employees that you are dedicated to, and the Home Office is coming and saying that you are doing everything or most of the things wrong. And their response is very emotional, and they, instead of using their rationality, they're now using their emotions, and they're not addressing the issues. They're actually saying things that is now nailing them to what the Home Office is accusing them for. So it's important to ask for someone to help you in these revocations, suspensions, judicial review, who will then come in from a professional point of view and help you to at least get a good result from whatever the Home Office is trying to do.
Absolutely. And I know, Dudley, you also work with a few solicitors yourself. So what would you have to add to that? What do you have to add to that, rather?
No, I think it's important. I think before the role, and it's slightly changed because before, when they came in, solicitors' roles were just to help with people, assigning them with their certificate of sponsorship, and was pretty straightforward when they started. And it was really more about compliance. Now it's the other end of how to save their business, how to avoid the revocation of licenses. And what I'm finding, hearing from a lot of solicitors, are obviously the people coming to them now, they're panicking, they're knocking on their door, now they've received the letter or the Home Office has spoken, and they want to resolve things as soon as possible. It's a process that has to take place, but then it goes back down to an audit trail, and how to make sure you're fulfilling this. Yes, I think the biggest take home will be that you should get a professional in. And yes, it's your business, so your business is worth so much to yourself. So understand that. But also as well, it depends on the different solicitors that come on here. There may be a possibility where you have a payment plan with them as well, so you can do that. So rather than it be so very stressful, and also as well, if before things get that bad, always get your mock audit in now. It's very helpful. So it actually, before it comes to that, or if you know that you may have done something wrong, it's for you yourself to actually go and reach out to someone before they come knocking on your door.
Absolutely. So how would you balance legal strategy with the emotional toll it takes on the business? You've touched upon this earlier, Andrew, where you said in courts, the providers start to get emotional and they start to actually talk about or act in a way that actually is against them and leans towards the case being presented by the Home Office. So still on the question of the role of a solicitor, how do you balance legal and emotional when it comes to business and supporting businesses?
Okay, so when we go to support a business, we really understand that the business is going through a difficult time, and most of the businesses or some of the businesses that we deal with in the health and social care space are either owned or run by one director or two directors. If it's two or three directors, it could be husband and wife or friends or family members. So all of them are really affected. And when we go to see them, obviously we are empathetic to what is happening within the business. We also suggest that their well-being is quite important. If they need any help in terms of counseling or therapy, we advise them to seek such, or if they've got any other way that they deal with their emotions or stress, some would go to their spiritual leaders, a pastor or an imam, to help them with that. But when we get in, we are there to do the professional work. We will still maintain our professionalism. Because some of the people are stressed, you ask them for one or two documents, they will take their time to give it to you. And remember, we are on, the clock is ticking. Maybe you've got 20 days, or we were within the 3 months of the judicial review to put it through. So we will have to periodically remind them, or even some of them, when you go to see them, because they're emotional, they might have an outburst on you as a lawyer, because you are kind of now putting more pressure on them on what they have, because you're asking for too much. You're asking for this document, you're asking for this system, you want to analyze their HR, you want to analyze their compliance, you are going on their CQC registration, you're asking them questions on those reports and so forth. So we have to kind of be a buffer of the emotions, even if they're emotional. We are there to help them, whatever emotion that they have.
Absolutely.
No, thank you. I think it's very important. I think going back to the whole element of the emotional toll, and I'll say those in this space know when CQC come knocking on the door, the panic is that the world is coming to an end. I think it's never nice when you're downgraded or something is taken away from you. But I also think as well, at the moment, there are, even though people's licenses may have been downgraded, it doesn't mean that you cannot reapply. It also doesn't mean that your business will end. And they also give you time frame to rectify some of the issues. So that's one thing I would say. If you are genuine and open and you've just made mistakes, the Home Office will give you time to be able to answer the questions. So you have a period of time. It doesn't just happen just like that. So do bear that in mind. If you are getting emotional, you are given, various time to respond. So before it's actually revoked fully, or suspended, you will have a problem. You have time regards to that. So that would hopefully allure some of the full emotions that you've got.
Thank you. So you previously rather spoke about mock audits. So I know, Dudley, you work with solicitors, and Andrew, you actually, do you do mock audits, Andrew? Does your company do that?
Yeah, we do mock audits, yeah.
Oh, okay. So can you give us a peek into what a mock audit is with regards to the Home Office? What does it look like, and how would it help a company be a lot more compliant?
So for most solicitors, or my colleagues that I've spoken with, we all try to mimic the process of the Home Office, which makes sense because that's what they do. So when I am going for a mock audit, we will request certain information from the employer. Will request for their files, employee files, their HR systems, their payroll, for example. And from there, we pick certain employee files. We request them that we need to interview a certain number of employees. We normally take about 20% of the employees that we want to interview. When we arrive at the office, we will obviously want to be treated as if we are the home office, even if you are our client, and if we are going to ask you questions, there is no words that we will go in every space of that we need to ask questions. We will interview the level 1 user. We will then also talk to the authorizing officer. We will look at the physical office. Do you have secure place to keep your files? For example, if you have got physical files rather than an online HR system. We will then interview the employees. We will then also review the files. And after we have done that, we will then make a report outlining the failures that we identified, the strengths that we identified, and we'll give you an action plan of what you need to implement after the audit. Then after you've implemented it, we will expect a feedback from the company. So that's how we do our mock audits.
Okay. Dolly, do you have any experience with mock audits?
Yeah, so what people don't understand is that people don't realize that these audits take longer than people think. And I think this is the problem, because they only have one thing in mind, maybe like a CQC inspection, and actually going through the mock audit. And I think you're very right. It can take a very lengthy period of time and be very thorough. So I always say the first questions, let them know, or any solicitor should let them know how long an audit takes. So there is no, there is no there is no confusion in what they'll be going to go through. So that gives you an indication. If someone says to you they're going to review for a certain amount of time, then you know it's going to be thorough.
I'm going back to a previous conversation we had. What happens when the level 1 user and the authorizing user is the same person? Does that pose a risk? Or would you advise that? Because sometimes when people have made an application, the level 1 user and the authorizing officer, they are usually the same. So does that usually pose a risk? Or would you recommend that the level 1 user is always different?
Okay. To me, it doesn't really matter whether the level 1 user and the authorizing officer one and the same person, as long as they've got the capacity to handle both offices. The issues are they able to do that? Because remember, outside of the SMS, they've got other responsibilities.
Yes.
And they are busy people. But some businesses have got only one person who's in the management, and they are therefore the one person. But if it is possible to have more than one person, I would say, even for the level 1 users, if you're able to have more than one level 1 user, so that you share the responsibilities, I think it's better that way. But where it can't, in terms of whether it causes any issues, I don't think it will, if someone is able to perform both duties properly.
Brilliant. Dolly, previously you mentioned reapplication when a license has been either, what was the word you used? Downgraded, yes, or revoked. So is there a cooling off period after revocation? And typically, how long would it take for a company to reapply?
I believe, and Andrew can correct me if I'm sure, I think it's 12 months before you can reapply again. So that's, and obviously before we get there, they're going to, obviously before you reapply again, you're going to have to jump through every single hoop possible, tick every box. And you may be fortunate if they give you maybe 1 or 2 candidates, but that is probably, and yes, some people might say 12 months isn't too bad, but if your business is, I know many businesses now are using up to 70% of their workforce from overseas. So this can really affect you heavily. So, and also as well, it's not just the fact of you losing the license, it's how you're looked at by various parties, and CQC won't be looking you very favorably as well. So, which is never great for your business.
Yes. Andrew, previously you mentioned that you don't just work with service providers, you also work with employees as well. So let's say a company does get their license revoked. What are the options for foreign employees who are already working?
Okay, so where the license is revoked, the Home Office would then send them a curtailment letter, and the curtailment letter will give the employees 60 working days to either leave the country or find an alternative way of staying in the UK. The letter is not sent straight away. Sometimes the Home Office might even take a month, and in some cases, more than a month after the revocation of the license of the employer before they even send the curtailment letters, which in that case is working in the favor of the employee because it's giving them more time to try to look for other options. And some, after they receive the curtailment letter, they will then have to, even before they receive it, they have to start to look for options of staying to the UK or start packing their bags to leave the country. And I've been asking the question, if you don't mind me saying this, by employers who have received the revocation,
Yes.
that are we still allowed to continue employing these employees? I've made an inquiry to the Home Office. Once revocation is occurred, the Home Office have told me that they will allow you to continue employing the employees up to the end of the 60 days notice.
That's
So
great information.
it gives the employer and the employees some time of, well, it's not a good time, a time to wind up their operations, so to say. There's something that Dudley alluded to in his talk, that a number of authorities are also getting involved. So where the revocation occurs, even the sponsor license suspension occurs, immediately the Home Office starts in telling the CQC, telling the councils, telling the hospitals and so forth. So there is a down road that happens from that moment going forward, which affects a lot of people. So it's then important to then look at the options and be open-minded of what is happening. While it's as much as you would want to maintain the sponsor license, sometimes taking the cooling off period might be a best option, depending on the cost that you're going to incur or the other complications that you're going to face. But obviously, the starting point is we want to maintain at least or get back our sponsor license.
I think you've said it all, Andrew. Do you have anything to add to that?
Just very quickly, you mentioned what can happen on the side of the actual overseas recruit. There is this classic line of the 20 hours and what they can do as well. So they potentially are able to go and work the 20 hours with alternative sort of providers. But once their Home Office has been made, they've been made aware. So they still can work, but only for a certain period of time.
Okay. So from your experience, what are the typical particular service types or company sizes which have issues like this, which have issues like these arising rather? I think I can actually answer that because you've said previously, Andrew, that at some point, every single provider will have a visit from the Home Office. So there is, well, I'll let you speak in short.
In short, yes. So from my experience, it's every size of company that will have issues with the Home Office. And when it comes to the sponsor license, my clients are not only in the health and social care space. I've got hotels, I've got IT companies, different industries. But obviously, a lot of problems have been in the health and social care industry because that's where the majority of the sponsor licenses have been granted by the Home Office. You will be surprised that some big companies don't have a compliance officer, for example. They don't do their compliance as well. And to them, they think it's not something that is important in terms of maintaining or having someone to look at it all the time, and even the level one doesn't get time to look into the sponsor license. And as much as it is an issue for small companies because the directors or management are too busy, because it's a small company, they're doing other duties as well. So these issues are across the board. And that's why it is important for every company, big or small, to either have someone dedicated in managing their sponsor license or outsourcing to people that can help them to manage the sponsor license.
Yeah, no, I completely agree. Just to add in very quickly, you mentioned service types and company sizes. So
Yeah.
just work on the back end of it. There have been some big reports that have gone into Parliament as well, and as written up. And there has been a huge element of, dare I say, to my fellow domiciliary care providers, where there has been maybe an extra magnifying glass put on them. But also as well, we understand as well, some size of companies, there've been some alarming cases and people have questioned how these individuals maybe only had 5 people working with them and managed to bring in about 50 to 100 people into the country. So there are some red flags. And if this company size is small and you're trying to grab as many things as possible, it's only going to alarm the actual Home Office to come knocking on your door. So let everyone be aware. If you're trying to be greedy, I would say be careful.
I feel like you've just opened Pandora's box there. We shall not continue in that line of conversation. Okay, so we're coming up to the end. We have 2 questions to go. Are there any recent changes to sponsor license regulations that businesses should be aware of? So, Dudley, you could go first because I know when it comes to regulations, you're always preaching. You're like the advocate for Home Office regulations. So please
I think
keep us up to date.
I think this is an interesting space because I think a lot at the beginning of the year we know things changed and the government decided to change this tact on the way people were coming into the country. There's an issue in relation to the migration concerns, and I think one of the biggest areas obviously was the dependents that are able to come in, and I think it's been said since the notion of the dependents being allowed to come in with someone, there has been a drop in applications, and so this has affected obviously things like sponsor licenses. The other side of it is there are a lot of also displaced workers already in the UK. So the notion of trying to get your sponsor license is still important, but also as well, its focus has been a lot around the staff that have been displaced in this country and trying to make sure that these things are correct. Other elements are now you have to be CQC registered. So I know there are a lot of supported living organizations who probably weren't CQC registered, or other organizations which were slightly CQC registered made the most of this as well. So they've also lost the ability to actually get their license, which is another area that has been affected. So these are sort of the main areas that have been affected. The other side as well is the pay as well has changed. So before it was, I think, the pay has gone up now for those who've come after that period of time. So which means it's more costly for some as well. So do bear that in mind. And I mean, it's very important that this is great, but also always when you're doing your calculations, work out how many you can bring in. Can you afford it? The cost of you bringing someone over, does it match what you're going to be spending and what business you have as well?
Thank you, Dudley. So Andrew, could you update us as to any recent changes that we should know?
In addition to what Dudley has said, I think it is important for the providers to periodically check for updates in the Home Office, on the notice board. Just even if you're doing nothing, just go and check because they put a lot of things on the notice board. And also, in case some people made applications for COS before beginning of April, because it's taking almost 18 weeks for the Home Office to give decisions. If you made applications before the 3rd or the 2nd of April using the odd codes, 6146, 6145, those are now redundant. You might be waiting for nothing. Please, you have to reapply using the new codes. Applying for those COS now, for those who have got experience, that would know about this. Back then, if you're applying for COS, even applying for a new sponsor license, back then, there wasn't a lot of papers required, evidence required. Now to apply for a COS, they are turning your office upside down. They want to see your contracts with the local providers. They want to see your HR system, your rota, the service provider details, all these kind of documents, a lot of things. Applying for a sponsor license for those who don't have a sponsor license who are listening to us. It's no longer like just giving them a company house registration, HMRC registration, and the sponsor license comes. They will ask a lot of things, but mandatory is what Dudley have said. CQC registration is mandatory. Without your CQC registration, you will not be able to get a sponsor license.
Fantastic. So finally, if a listener is worried about their compliance, what is the first step they should take? Should they contact you directly, Andrew? Should they contact you, Dudley? Or is there something else they can do first? So let us know.
Well,
Andrew,
I'm gonna let Andrew take this one first, because I think it's only fair of what I will say after what he said.
Yeah, you are the compliance guru, so you will take the most of the question. But I will say charity begins at home. Before you call in someone to help you with compliance, what exactly have you done within the organization? Because you might call me or Dudley to come and tell you what to do, and you're not going to do it because you are that person who doesn't do things. There are some basic things that you need to comply with. For example, beginning of April, the company's house announced that there are some changes that they're going to have to do, regarding contact details. If you're using a PO box address, for example, it's now mandatory to have an email with the company's house. Compliance is a lot of things. So you need to be someone who will be able to comply with everything. Company's house, HMRC, Home Office, CQC, and any other stakeholder that we deal with. You have your own systems. I'm surprised some businesses, when you go to see them, they don't have an HR system. Even if you're not going to have the prescribed or the ones which you pay money for, you have some systems that you have. Do you have an employee handbook? How do you do your contracts? Some of the contracts are extracts from WhatsApp and Facebook groups. And how are you compliant in such a thing? So you should be compliant to the compliance. And when we come in, we are now checking on what you have done. Because when you come in, there's nothing, then that begs a lot of questions.
Okay, well, I'm surprised. What I would have thought Andrew would have said first is come and see a lawyer, quote, get a lawyer's help in first. But just to add to what Andrew said, and what we found and studies found and CQC are looking at is that if you, for example, are not good at compliance on a daily basis in your role of work, there's a chance that your compliance with the Home Office is also going to be bad. So this, and when you go into this space, if you're already having issues with compliance already, is probably a question you should ask yourself before entering this space in trying to apply for a license or certificate, should I say, in the first place. So if that's the case with yourself, then you make sure then you either get a professional in, or the other area will be to make sure, as Andrew mentioned before, you check all with the Home Office, what all the updates are, CQC, HMRC, make sure you're not falling foul of anything to do with the gangland abuse authorities as well. So those people for, abusing any type of workers, please look at everything possible so that you do not fall foul of it, because now they are looking at various areas. It's coming from all angles, unfortunately. So the more help you get is important. And one thing I would say, which is, I think people forget, is if you know someone who's done it well, try and go in shadow with them. Listen, have a look what they've done, learn from what it takes, ask someone questions so you don't go in there blindsided, because it also helps to give you the reality of what you will be dealing with.
Thank you very much, Andrew. Thank you very much, Dudley. Charity begins at home, remember. And yes, see a solicitor, but also get your ducks in a row. This conversation has been incredibly informative for our listeners, and even for me, I must admit. Thank you for sharing your expertise. And to our listeners, thank you so much for joining us today. We hope you found this episode insightful. Thank you for tuning in, and we will see you next time. Andrew, thank you so much. Dudley, thank you so much for your time. Always a pleasure to have you on here, Dudley. And Andrew, as is your first time, I hope you will be joining us again.
Thank you so much for having me. And Dudley, thank you so much for being on the panel with me.
And thank you, Andrew, for your knowledge, because without your support, many people may not be able to be compliant and actually walk around what is a necessary area of support that's much needed.